So we just got an early Christmas gift. The federal law which prohibits nonviolent felons from possessing firearms has once again been ruled unconstitutional after the Supreme Court's recent 8-1 decision and GVR of that case. Now, before we jump into this video, I want to wish everybody a Merry Christmas. I hope you guys enjoy the Christmas season with you and your family. I hope you guys get all the firearms gifts that you asked for. And again, just thank you guys so much for all the support. If you want to support the channel even further, you can subscribe to the channel. Make sure you hit that like button, share it around. But regardless, thank you guys so much for all you do for me and the channel. Now, also, if my voice sounds a little bit off, that's because, of course, I got sick right before Christmas. So again, my voice is a little bit off. But in this video, we're going to be talking about a huge Second Amendment case and decision that just came out after the Supreme Court issued a recent GVR of this case. The case we're going to be talking about is Range versus Garland, and we just got a huge decision this morning from the Third Circuit en banc panel. This Range case involves a challenge to the federal laws, which essentially prohibit someone with a nonviolent felony or potentially a misdemeanor equivalent from being able to own, possess, or acquire firearms. And this is the lifetime ban that is currently in place on these individuals who have maybe felonies. Now, this Range case interplays with a different case, which is the Rahimi case, and the Rahimi case was recently ruled on by the Supreme Court in an 8-1 decision. In the Rahimi case, the Supreme Court upheld the federal law which restricted the possession of firearms for someone who is subject to a domestic violence restraining order. But in the Rahimi case, that was focused primarily on temporary restrictions. The Supreme Court believed that there were historical principles that supported that type of temporary restriction, and so that's why they ruled that way in Rahimi. And because of that decision in Rahimi, the Range case was then sent back down to the Third Circuit en banc panel for a new decision in light of what they just said in Rahimi. And this morning, the Third Circuit once again ruled that as applied to Mr. Rahimi, this federal law is unconstitutional because Mr. Rahimi is still among the people mentioned in the Second Amendment. So let's break down some of the important points of this decision and what is going to happen now going forward. 26 years ago, Mr. Range was convicted of concealing some of his income so that he could obtain additional food stamps for his family. Essentially, he simply made a false statement on a federal form to get food stamps. And because of that one lie on a federal form, he was charged and convicted of a Class 1 misdemeanor in Pennsylvania, which became a felony equivalent for federal purposes. And now he is barred forever from being able to purchase, possess, acquire, or potentially even use firearms forever. Mr. Range brought this lawsuit originally before a district court in Pennsylvania, a federal court, and it was against the Attorney General and the ATF. However, the federal court ruled in favor of the federal government, and they ruled on a motion for summary judgment. Mr. Range appealed up to the Third Circuit, and on review, a 3-judge panel in the Third Circuit issued an opinion upholding the lower court's decision, citing to Bruin. So there, the Third Circuit 3-judge panel found that his misdemeanor, although non-violent, qualified under 922G1 and therefore excluded him from the class of the people afforded the right to keep and bear arms. So they ruled against Mr. Range and found that he was not among the people. Well, Mr. Range did not quit there, which good for us, he did not quit, and he sought en banc panel review in the Third Circuit. And for the first time on review, the en banc panel ruled in favor of Mr. Range. They found that 922G1 as applied to Mr. Range is in fact unconstitutional and violates the Second Amendment. Now, after that original Third Circuit en banc panel decision, the federal government then sought Supreme Court reversal. They filed a petition to the Supreme Court, and they wanted the Supreme Court to reverse what the Third Circuit said. At that time, the Rahimi case was pending. The Rahimi case, like I mentioned, was issued. It was an 8-1 decision. And then what happened in this Range case is the Supreme Court decided to grant, vacate, and remand this Range case back down to the Third Circuit en banc panel for a new decision in light of what they said in Rahimi. At that time, my prediction was that the en banc panel in the Third Circuit was simply going to rule the same way. It was going to be a very similar ruling, even in light of what just happened in Rahimi, and I was correct. Today, we received a decision from the Third Circuit en banc panel, and once again, they ruled in favor of Mr. Range. They found that the lower court was wrong in finding that he is not among the people for the purposes of the Second Amendment. Now, before we get too deep into the analysis, I do want to thank one of the main supporters of the channel, which is Brownells. Brownells is an amazing company. They support the channel here. They're huge friends of the Second Amendment. Their company does a lot to promote 2A causes. They donate a lot to 2A causes, so check them out. Again, I just wanted to mention that the channel is sponsored by Brownells. They do a ton for us here on the channel, so if you want to support a solid company that just does amazing things for the Second Amendment, go check them out. In the decision, the Third Circuit stated that we agree with Range that despite his false statement conviction, he remains among the people protected by the Second Amendment. And because the government did not carry its burden of showing that the principles underlying our nation's history and tradition of firearms regulation support disarming range, we reverse and remand. Now, in this ruling, there were only 2 dissenting judges, but there was also a hodgepodge of concurrences and even a concurrence only in the judgment of the case. They state in the ruling that at the root, the government's claim that felons are not among the people protected by the Second Amendment devolves authority to legislators to decide whom to exclude from the people. We reject that approach because such extreme deference gives legislators unreviewable power to manipulate the Second Amendment by choosing a label. And that deference would contravene Heller's reasoning that the enshrinement of constitutional rights necessarily takes certain policy choices off the table. In sum, we reject the government's contention that felons are not among the people protected by the Second Amendment. Heller and its progeny lead us to conclude that Brian Range remains among the people despite his 1995 false statement conviction. They then move on to the next step of the Second Amendment analysis, which they state is a very easy question for them to answer. They state in the opinion that having determined that Range is one of the people, we turn to the easy question, whether Section 922G1 regulates Second Amendment conduct, and they state that it does. Range's request to possess a rifle to hunt and a shotgun to defend himself at home tracks the constitutional right as defined by Heller. The question then was whether or not the federal government can show that they have any historical traditions or any historical evidence to support these restrictions that they are applying against Mr. Range. And the en banc panel in the Third Circuit found that the federal government once again has failed that burden. They cannot meet that analysis. They don't have the required evidence to place this restriction on Mr. Range. They state that in attempting to carry its burden, the government relies on the Supreme Court statement in Heller that nothing in our opinion should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons. Here, the Third Circuit en banc panel found that the 1938 statute that was the basis of this felon in possession restriction does not qualify as long-standing, and even if the federal government attempts to justify the law with founding era evidence, that also fails. So not only the 1938 statute was that not long-standing enough to qualify as a tradition, but also all the founding era documents and evidence that they used to try to justify this restriction as applied to Mr. Range also did not pass the analysis. They point out that even in the Rahimi decision, the Supreme Court said only temporary disarmaments may be justified historically, but the categorical and permanent lifetime bans, which are in play here in this case, have no historical justifications. They concluded by saying, our decision today is a narrow one. Brian Range challenged the constitutionality of 18 U.S.C. Section 922G1 as applied to him. Range remains one of the people protected by the Second Amendment, and his eligibility to lawfully purchase a rifle and a shotgun is protected by his right to keep and bear arms. More than 2 decades after he was convicted of food stamp fraud and completed his sentence, he sought protection from prosecution under Section 922G1 for any future possession of a firearm. The record contains no evidence that Mr. Range poses a physical danger to others, because the government has not shown that our republic has a long-standing history and tradition of depriving people like Range of their firearms under Section 922G1. It cannot constitutionally strip him of his Second Amendment rights. We will reverse the judgment of the district court and remand so that the court can enter a declaratory judgment for Mr. Range. So that's a big win against the felon in possession laws that are currently in place. Now, this applies specifically potentially to just Mr. Range. It's an as-applied challenge, and it deals more primarily with nonviolent felonies like the food stamp issue here. But this is still a big win, a big decision, and opens up the door for more as-applied challenges against 922G1, and means that the permanent lifetime bans are potentially unconstitutional, and that the government here cannot prove any historical evidence to support those types of lifetime bans. Now, I have no doubt that this will eventually make its way back to the Supreme Court. I think the Biden administration, kind of one of their last Hail Marys, kind of their anti-gun move before the transition to Trump, they're probably going to file for a petition for Supreme Court review. I think they're going to try to get this back to the Supreme Court. They're going to try to file their petition fast. But I think the Supreme Court will ultimately rule the same way here. Maybe they'll just take their loss and decide to not appeal this to the Supreme Court and just let this sit isolated to just the Third Circuit. But we're going to have to wait and see how that plays out. So as we get more information, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you guys for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.